can do that. All right, welcome everybody to our February meeting, this nice cool day in February, and we are so excited to have our Ware team on the call today with us. Sara Ackermann is our main speaker today, but she has also brought a team with her that is going to give us some updates and from what I understand, it's COVID and maybe some more. So I'm going to let Sara take this away and move forward with that.
Awesome. Hi, everyone. We're so excited to kind of get to see some of you anyway. I think last year, if I recall correctly, we were at Nelson Jameson. Do I have that right?
You are correct.
For the tour. God, I can't believe that's been a year. Oh. So right before everything kind of happened, I believe that was probably the last live presentation I did for a group. So anyway, I'd like to start off and hopefully just before we get into what I normally do for you every year, which is a review of the past year's employment law decisions, I have invited Nicole and Bob to join me for this opening so they can give a little bit of an update on what's going on with COVID. All of us, Mary Ellen Schill was hoping to join us, but she's tied up on client matters. So I'll try to summarize some of the things she was going to talk about. Okay, so now I'm going to try to move the screen. And it's not, yay! Oh my God, amazing. Okay. Okay, so ask questions anytime. I know everyone's used to like sending in the chat questions, and I'm gonna have Karen try to, watch for those so I don't miss them. But then this is a pretty small group, so we could also unmute you and have an actual conversation. So we'll just see how that goes. Obviously want to stay on track time-wise, but please ask questions as we hit the topic. I'd rather do that than wait to the end because I know other people might have the same questions you do. So I'd like to, when we're on the issue, feel free to jump in. Okay, please work. Okay, it's not working. Hold on.
Give it a minute.
Give it a minute. I'm really not doing anything differently. Okay. So Nicole is a new attorney with Ware. We're super excited to have her. She started in the middle of the shutdown. So she got to learn how to work remotely really quick, but we're so excited to have her on the team. She's going to specialize in employment law. And she has been working closely with me on, you've probably seen her smiling pretty face on e-alerts. She's done a ton of those, helping us keep you all informed as really when the FFCRA hit. For those of you under 500 employees, I think that's almost everyone, we had to learn that law really fast. So Nicole really helped a lot with trying to stay on top of that, help us with e-alerts, et cetera. And most recently, we've been struggling with, okay, how do we handle this in 2021 if employers want to extend FFCRA? And one of the things Nicole's going to talk about is how that intersects with Fmla. So I'll let her address that.
Yeah, so the FFCRA was not extended into 2021 in the sense that it's mandated for employers anymore. So, but they did extend the tax credit. So employers have two options as we moved into 2021. You can just stop giving the paid sick and family leave under the FFCRA and go about your business, or you can choose to extend it if you want to and then claim the tax credits. Currently it's through March 31st. I haven't seen any extension of that yet. So keep your eyes posted if we post an e-alert, if that would come down. But if you do extend it and you do it because you want the tax credit, then you need to make sure you are still following the FFCRA leave as it's written in the FFCRA. If you make any changes to it, there's no guarantee that you're going to get that tax credit. So if you're doing it just out of the kindness of your heart, you can kind of change it up, do it how you want. But if you're doing it to get that tax credit, you need to make sure you're carrying it over from 2020 like you would. You also need to make sure you're doing it uniformly. So if you're going to extend it, you can't pick and choose who you extend it to, because that may open you up to discrimination claims if you're giving it to some and not others who may be in a protected class. So our advice is if you're going to extend it, just do it uniformly, carry it over. And again, it's only for those employees who haven't taken the FFCRA leave in 2020. So if they already used it up, they don't get more of it. And then as we go into 2021, we need to look at the FMLA and whether or not normally eligible employees could take FMLA. They may not have hit that hour requirement. So under FMLA, you need 1,250 hours in the previous year. So 1,250. And under the FMLA, it's very strict. It's hours worked. So any leave that was paid or unpaid don't count towards that hour requirement. So in 2020, we had employees who took FFCRA leave. They may have taken other leaves. They may have taken FMLA. They may have just taken unpaid leave because they needed to. So if you have employees in 2021 who are starting to look for FMLA, you need to make sure they're still eligible and they still hit those hours back in 2020 for them to take that leave in 2021.
Excellent. Awesome. Any questions about that FFCRA while we have Nicole with us? Because she's going to drop off because she doesn't need to listen to me babble for the next hour. And of course, if you have questions come up as we go, I can address them too. And I think the biggest, and I think Nicole addressed this, but one thing I want to reiterate, one of the biggest areas of confusion with that whole thing, that whole extension is, well, what if we're hiring new employees in 2021? No, they don't get it. Unless you want to give it to them out of the goodness of your heart, you won't get the tax credit. This is not, they weren't here when it was implemented, so they don't get it. All right, thanks, Nicole. And now Bob Reinertsen, another familiar face. You have seen him at seminars, presentations that he has done, and also tons of e-alerts this year about really focusing on OSHA-related guidance on the pandemic. And most recently, OSHA issued some more guidance, and he's going to talk a little bit about that.
Thanks, Sarah. Good morning, everybody. It's a pleasure to be with you today. So OSHA is part of the Department of Labor, and that department has been on President Biden's radar for quite some time before taking office. As soon as he took office, he announced that there would be a new Secretary of Labor that probably will be a little more employee positive as opposed to a former administration being a little more employer positive. The new secretary is the former mayor of Boston and a union leader. The president also fired the employer positive general counsel to the National Labor Relations Board, so that's another indication. But aside from that, on his second day in office, the president issued an order to OSHA. Among other things, it required that OSHA issue a new guidance on COVID-19 safety. There had been one in effect since last spring, but the president felt that it should be stronger. So he told OSHA to come up with one. Secondly, he told OSHA to decide if a new national and mandatory standard on COVID-19 safety was necessary, and if so, to issue it by March 15th. And thirdly, he ordered a national program heavily focused on COVID-19 enforcement activities. So on February 1st, the first thing was done. OSHA did issue the new and stronger guidance. It contains many things from the former guidance, which by now are common sense and well known to everybody: social distancing, face masks, hygiene, cleanliness, those sorts of things. But a couple of new things. One is that employers are not supposed to distinguish between employees who have received the vaccine and those who have not. Meaning that employees who receive the vaccine must, and they use the word must, continue to follow safe practices. And employers must use reasonable steps to try and make sure that they do. This is because OSHA says that there's not enough evidence yet that the vaccines actually prevent the transmission of the disease from person to person. Secondly, employers should provide free face masks to employees. I know a lot of you are already doing that. And thirdly, the guidance says that employers should make the COVID-19 vaccine available to all eligible employees at no charge. It goes on to say that employers should inform employees of the benefits and the safety of vaccines. Now, presumably, that's about all you can do at this point because the vaccine is not readily available. But presumably, if and when it is, this guidance might be interpreted to say that employers should treat the vaccine like many do with flu shots, holding a flu shot clinic and a COVID-19 vaccine clinic at some point. Anyway, the new guidance is at this point advisory. It's not a law, but I do caution that if employers don't take reasonable steps to minimize COVID-19 risks, they could be at risk for being cited by Osha under the general duty clause. And that, of course, is that very general statement of law that's been around since Osha was created in 1970, which simply says that employers must provide a workplace that is free from recognized hazards that are causing or could cause serious physical harm or death. Anecdotally, we've seen a rash, or at least a mini rash, of OSHA enforcement activity in response to employee complaints. OSHA has told its inspectors to try and hold off on going in person to places to inspect. However, they will always respond to an employee complaint. And we've been seeing some COVID-19 related complaints, and OSHA's coming out, and they are, and of course, when they come out, anything is fair game in their line of vision. So whatever they see at the workplace that is not up to standard, in their view, it's fair game for a citation. Because OSHA has not had any mandatory national standard up to this point, they've been heavily criticized, which I'm sure is behind the president's order to them to decide if a mandatory standard should be in place and to do it by mid-March. I think it's likely. It will likely include the things that are in the new guidance, so I commend that to your reading. It's easily found at the website osha.gov, and I'm sure it will include some things like a written COVID-19 response plan, making sure employees are trained on the plan. There might even be some requirement to assess risks of every task in the workplace to see what kind of, say, equipment, safety equipment employees need, things like that. So look for it between now and March 15th. I have a feeling it's pretty likely to come. So.
Awesome. Thanks, Bob. Anybody have questions for Bob on that latest guidance and what might be coming up? I will also say that I've seen more OSHA retaliation complaints brought by employees claiming that they were fired because they had COVID, or fired because they had symptoms, or fired because they complained about mask wearing, and more ever than in my entire career in the last 6 months. So probably 1 or 2 of those a month on my desk. So employees who are terminated during this time and don't really understand the reason why they got fired, or are angry about why they got fired, that's another avenue they can take to make your life not very fun. Well, thanks, Bob. I don't see any more questions.
So Sara, would I know Bob had referenced a few links or resources in his thing. Would you mind, Bob, dropping that into the chat for links to that anybody can take advantage of, especially if they're coming back to this on a recording?
Yeah, it's osha.gov is the website, and right on the first page of the website, there's a noticeable link to the guidance, to the new guidance, and that's all you really have to do. And click on that, and that will bring you to it.
Okay, great. Thank you.
Whoops. Of course, I'm trying to type a message and it's not letting me.
It's in there, Sarah. I see
Oh,
it.
it is? Oh, it
Yeah.
is.
Oh, there it is.
Okay, it did go. Okay, awesome.
Thank you.
So Mary Ellen couldn't join us. I will just summarize that this area of should we or should we not give an incentive for employees to get the vaccine is very gray right now. We know there are nationwide employers who are giving, I know the Dollar Store or Dollar General, they announced publicly they're going to do 4 hours of paid time for everybody who gets it as an incentive. The EOC has not given any guidance to us. So several employers, several organizations, including National SHRM, Society of Human Resource Management, have drafted a letter begging EEOC to tell us, hey, can we do this? Is this going to be a violation or not? And we're waiting for that. So in the meantime, if you have questions about what to do, I would probably consult legal counsel, call Mary Ellen. She can guide you as to kind of through this, navigate the waters through this right now, because it's kind of up in the air. The final question we're getting is, can we fire people who don't get the vaccine? And we don't encourage that, just for many reasons. One is morale. People are still scared. People are nervous about this. People are looking at it. People don't even have it, access to it yet. So announcing a policy right now saying, hey, everybody, just keep in mind, once it's available, if you don't get it, you're going to get fired, is not a good idea on several levels. Also, because of the emergency status of the vaccine, it is under EAU status, not full federally approved status. All individuals must be told at the time when they get the vaccine that they can refuse it. They cannot be forced to get it right now. So that creates uncertainty in the law regarding whether they could sue you if they get fired for refusing the vaccine, because lawfully we can't force them to take it. So that would be a violation of public policy. There's a wrongful discharge claim they could arguably bring against you. So really be careful about, while you want to encourage people and you can talk to people about it and you can educate your employees about it, just be careful about drawing any lines in the sand right now. Okay, any questions about that? Okay, and now I'm seeing how the screen, I think it doesn't like me right now, but I just have to wait. Come on, there. So just quickly, the rest of my presentation is going to be about cases. And what I like to do for this presentation is pick cases that really illustrate how the process works under both federal and state law. So often the question I get is, if we fire them and they sue, can we win? And that's not really, by the time you get to the win or lose, it's hundreds of thousands of dollars of attorney's fees and years of time. So usually you don't want to focus on the end game, you want to focus on the process and where throughout the process can you prevail in maybe getting a case dismissed or settling a case favorably for you. And just real quickly, in Wisconsin, most of you all know this, but I'll just cover it again. In Wisconsin, an employee has 2 avenues which they can choose to file a claim. One is through the Equal Rights Division, which is under state law, and one is the EEOC, which would mean they are bringing a claim under federal law. Why do they pick one or the other? Well, under state law, we have more protection for different classes. Marital status is protected under state law, for example. Sexual orientation used to not be covered under Title VII, but as we're going to talk about, that is now covered under Title VII due to a recent case. So there are certain things that are not covered under state law that are covered under state law that are not covered under federal. Also, it's much easier the process to navigate without a lawyer is much easier under state law. So, or even with a lawyer, it's easier to get an attorney to represent you under state law because it's just a very easy process. You don't have to it takes a while before you are ever in court. So these are just some slides you can read on your own time in the event you're curious about kind of the different process of one agency versus the other. Most of the cases I'm going to talk about and what we see most on our desks here at Ware are cases under the Equal Rights Division. And that process is employee files a claim, the claim goes to the employer has an opportunity to file a position statement giving its side of the story. The Equal Rights Division investigator, who by the way, these are not lawyers, they just college grads usually, maybe they have another degree, but they're not attorneys. They review the position statement and their total job is to determine, is there a question of fact here? Is there a dispute about why this person got fired? If there is, it's going to go to a hearing. If there's not, we have clear documentation that shows why we fired Sara, it's slam dunk, then it's going to be dismissed. So in the event probable cause is found, it goes to a hearing, which is like a mini trial. Administrative law judge issues an opinion as to whether who wins and who loses. If either party is unsatisfied with that result, they appeal to Labor Industry Review Commission. That is a 3-body panel in Madison. There's no other hearing. They just look at the stuff and they decide whether the judge got it right. If that decision is not favorable to a party, they can appeal to the local circuit court judge, Court of Appeals, and then the Wisconsin Supreme Court. That does happen occasionally, and that takes years and years and years to litigate, but the process can go all the way up and come all the way back down. So first off, I want to cover what you all should know already, that finally, and I've been reporting on this case, I think 3 years in a row now, and finally the Supreme Court ruled in June on this case, Bostock versus Clayton County. It actually combined a couple different cases regarding transgender rights under the federal law of Title VII, transgender rights and sexual orientation rights. And the Supreme Court came down with its decision saying, yes, transgender people are protected under Title VII. The word gender is right in the statute, people. So I don't think this was a big shock. Shouldn't have been a big shock to anyone. Also, yes, sexual orientation covered by Title VII. The word sex is right in the statute. So employment lawyers are not shocked at all by this decision, although from a political standpoint, it was quite divisive. But it is what it is. Now we have in the state of Wisconsin, we already have under state law, sexual orientation is protected. But now under federal law, sexual orientation is protected, as is transgender status. So not a huge shock, but it is now finally law in the country. So what does this mean? Well, it's disconcerting to a lot of people. This is new stuff. I get a call probably once a month from a client saying, what about this bathroom thing? You know, I have someone who's now telling me they want to be, they're transitioning to a woman. They look like a man to me. Wow, am I going to let this person use the female bathroom? Yes, you probably are going to. And it is a sensitive issue and you need to navigate it carefully. But the bottom line is, if you start denying individuals to use the restroom, locker room, bathroom of their desired identity, you're just asking for litigation. There are lots of lawyers who want to make a name for themselves under the statute. So I would definitely work with legal counsel. I would not deny that without getting some legal advice. Obviously, if you think someone is fabricating their desire to transition just so they can be peeping in the bathroom of the opposite sex, that's not going to be tolerated. But I think what companies need the most from HR is helping explain to coworkers who are uncomfortable. And what some of my clients are finding is this isn't that big of a deal. You know, people don't really, the owners of the businesses might think, oh my God, everyone's going to freak out. People are like, it's a bathroom. So also, if you're doing new construction, and we talked about this last year at Nelson Jameson, they have unisex bathrooms, you know, some bathrooms available that are just one stall with a door. That's great. You know, the more accommodating you can be, I think this is we're going to see more and more of this in the future. Another couple things, use of pronouns, names. I know some of my clients are asking individuals to identify, do they want to be called he, do they want to be called she, do they want to be called they? That's very progressive. That's awesome. Make sure your dress codes, as you review handbooks and policies, you should not have anything about sex or gender in the dress code. Either, you know, you don't want spaghetti straps, you don't want women to wear them, you don't want men to wear them. I don't want to see spaghetti straps at work. I don't care who's wearing them. So why discriminate on the basis of gender or sex? Just have policies that are neutral, and then no one can dispute them. So ADA and FMLA, the most litigated area, one of the most litigated areas we see here at Reuter, failure to accommodate, interference with FMLA. I would say that's one of the top cases, the top complaints that we get. So pretty big part of our practice. So this case is actually a federal case that came down in the 7th Circuit this past year, Valdivia versus Township High School District. So Norma worked as an administrative assistant for Angela Sissy, who was the principal. Before being assigned to Angela, Norma was fine. And she'd worked 6 years assisting somebody else. We don't have all that history in the case. I don't know why she suddenly was assigned to Angela. Maybe it was a promotion, but things started to go south for Norma when she started assisting Angela, coincidentally, perhaps. So suddenly Norma starts having attendance issues. She's showing up late. She's got to leave early. She's crying uncontrollably at her desk. She's telling everyone, all of her coworkers, about her symptoms. Wow, suddenly I feel horrible. I can't sleep. I can't eat. I'm losing weight. I feel terrible. I have no energy. Finally, her boss, Angela, says, Norma, meets with her. Is like, what's going on with you? I mean, can you work? Can you do the job or not? Because this isn't good for anyone. And Norma breaks down crying. She's sobbing. She says, I don't know. I don't know what's wrong with me. Something's wrong with me. Maybe I should just take a medical leave. Angela doesn't really say anything. Angela just, ends the conversation. There's no evidence they really discussed a medical leave, or, Angela just basically said, do we got to do, I think, something like that. So 1 week later, Norma issues her resignation to Angela and says, I'm resigning. I'm giving 2 weeks notice. Then a week later, or I guess two days later, after she gives Angela her resignation, she changes her mind. She shows up at Angela's house on a Sunday morning, knocks on the door, crying to Angela, please, please, I need to rescind my resignation. I didn't mean it. I need this job. Angela's like, you woke up my kids. I don't like that you're here. This is annoying. I'm annoyed with you. This is not working out. We're keeping the resignation. I'm not allowing you to take it back. So Norma works out her notice. And Norma works out her notice, and Norma ends up getting help, going to a medical provider and getting diagnosed with anxiety disorder and major depression. So she eventually finds a lawyer, or somehow does research and hears about this thing called the FMLA, wonders why she didn't get it. Why wasn't she offered FMLA, and she sues. And the school district said, what? FMLA? We got posters, we got HR people, we got policies in the handbook. She never said anything about FMLA. She never once mentioned FMLA. And the 7th Circuit said, it doesn't matter. Everyone knew she had problems. Everyone was on notice. Her supervisor cannot deny she was crying uncontrollably at work, leaving early, coming in late, and tying all of this to a medical issue. Even though she didn't know what it was, she was tying it to a medical issue. There are no magic words required for FMLA. Burden is on us. We are the ones, if we see, we meaning management, right? That's when everything, management or HR, if we are on notice that an employee is missing work due to a health condition, give them the paperwork. This is nothing new, although the 7th Circuit had never addressed this specifically before. So in our circuit, where Indiana, Wisconsin, and Illinois, all of, that's our little federal area, we didn't have clear guidance on this. So it's nothing new. Lesson learned is train your people so that they know when to get to you to send that paperwork out. So this one, harassment is not always based on sex. Again, another federal case, Ford versus Marion County. Bridget Ford injured her hand. She could not be accommodated. She was a deputy for the county. Everyone agreed, no dispute, she can't do that job anymore. So they did what they're supposed to do under the ADA. They transferred her to another position for which she was qualified. that was open. They didn't have to create a job. They had a job called the jail visitation clerk position. She moved into her new role. Obviously, this is a lot less prestigious than being a deputy. And she got teased a lot, and her coworkers made fun of her, and she'd go to lunch and they'd move all her stuff around and they'd hide her stapler and, kind of like office pranks you would see Jim do to Dwight. So they did a bunch of that, and she complained. She said, my coworkers are making fun of me. And the county said the county didn't do anything about that. Well, then a couple months go by and she complains, my coworkers are making fun of me because of my disability. That raised red flags. They immediately investigated. They immediately transferred the coworkers. Well, by then she's already talking to lawyers and she's really mad. So she sues for disability harassment. My coworkers are creating a hostile work environment, all because of my disability. And when it went to the Seventh Circuit said, yes, this is a claim. People can sue for disability harassment. However, in this case, as soon as management was aware of the issue, they stopped it. It's kind of like you get one chance, just like sexual harassment. If it's not involving management and coworkers are doing things to coworkers, as soon as management finds out about it, you get the one chance to stop it. And they did. They took immediate action. They transferred the bad people, never happened again. So how could litigation have been avoided? Well, when she complained the first time, they obviously didn't dig deep enough to get the real story that they were making fun of her because of a disability. And the lesson here is when you have employee complaints, and I know this is hard because it's frustrating because people complain all the time and you can't do a 5-star investigation on every single complaint because people complain all the time. But when the complaint is based on a protected class, that has to move up on your priority scale. So if it's just, no one likes me, John doesn't smile at me, I don't feel like people want to eat with me at lunch, but it's, well, why do you think that? I don't know, they just don't like me. Any particular reason? No. If you dig into it, yes, it's still bad. You don't want people treating each other poorly in the workplace. But if it's, well, they said it's because I'm Jewish, or they said it's, they're making fun of me because of my limping, then boom, that's when you really got to jump on it. So what could they have done differently to avoid litigation? Maybe take her seriously the first time. And maybe they did, and she never tied it to her disability, and they did what they thought was best. Remember, you can ask questions. I wish I was there live to pick on people. Okay, come on. So Stelter versus Wisconsin, basically WPS. So 7th Circuit case here, Mary Lou Stelter, she was sales support for the insurance company. In 2013, in her performance review, it says right in the performance review, you need to start learning more about our products and you need to not miss work for personal appointments. This is getting out of control. So that's in writing. 2014, she has a back injury at work. Again, she has her normal review comes around, same supervisor says, look, sorry about your back, but we still need you to start. You're not doing these things that we talked about in 2013. You're not taking an effort and interest in learning about our products, and you are still taking too many personal appointments. The case is not specific about the personal appointments, but we have to assume they had nothing to do with their back because that would have been a problem. So I don't know what they were about, but they were not about her back. So good job, supervisor. He or she does the review in 2014 and puts her on a PIP. And AAA+ starts weekly meetings with her, which is hard. And this is what we all want supervisors to do, but they also have their real job they want to do. So this is great. The supervisor actually did it. And triple bonus, took notes. Great. Took notes from the meetings and gave them to HR. So she has notes that say, look, I'm meeting with Mary Lou every week. She's still not doing what she's supposed to be doing. I'm not seeing any improvement. So eventually we get Mary Lou terminated. Of course, she sues saying, this has nothing to do with my performance. I just hurt my back. This has to be because I just hurt my back. It has to be because of my disability. And the 7th Circuit said, look, there's no evidence at all that this supervisor, who was her supervisor before she hurt her back and her supervisor after she hurt her back, had any animosity towards her because of this back issue. This is very clear and convincing documentation, great work supervisor that supported every single action up to and leading to termination. So this, what do we learn here? Document, document, document. And I know this is hard and supervisors don't have time, but it is so critical in these cases to help get a case dismissed, and even earlier than getting to the Seventh Circuit usually. The second lesson, and this is true of every case, so I just want to point it out here. She got fired in 2014. When did this case get decided? 2020. That is 6 years of litigation. That is 6 years of, wow, is the supervisor even going to be here when we get to trial? You know, it's very unsettling to be sued by an employee, even a former employee, and go through litigation for 6 years. So again, all the more reason to be careful in these cases and not really worry about winning, but let's try to, you know, avoid litigation in the first place, because it is long and stressful. So this is a rare case of association, disability association discrimination. We don't see these very often. So Frank worked for Medline, and we do see this fact scenario a lot though, by the way. You probably all have experience with this. So Frank asks his supervisor for a new shift. He wants to work 4/10s. His grandfather is ill. He takes care of his grandfather. So supervisor's like, sure, you can work 4/10s. After 6 months, Frank is not performing well. Frank is really a pain in the supervisor's butt, and the supervisor is sick of bending over backwards to help Frank and says, Frank, you got to go back on 5/8. This is not working on several levels. So Frank is really mad, and he's like, I am so upset. I have anxiety. Now I need to go on FMLA for my own leave. So he goes on FMLA. They give him FMLA. FMLA is exhausted. He goes on short-term disability. Great. Now he's on long-term disability. So Medline's like, and this is what you should do. Once someone's on long-term, we need information regarding your chances of returning to work. We have the right to know when you can come back, because a sign of going on long-term is that you're probably not going to. And they ask him for information, They have letters in writing. He doesn't respond, and they end up terminating him, and he sues for a million things. But most importantly for this case, he said, you're terminating me because I have an association with a disabled person, which is my grandfather. Now, these claims are rare, but you should know about them so that you can make sure you're avoiding getting trapped in one of these. So the Seventh Circuit said, look, this claim exists, but usually one of the following things has to happen. First of all, you have to show your employer terminated you because they're worried about this relative who's disabled being on your health insurance and being a health insurance issue. Number two, you have to show your employer terminated you because they were so fearful of your disabled relative or association with this disabled person that you were going to somehow get a disease from them and bring it into the workplace. And three, or they terminated you because they really, you know, you were a little distracted at work, and they should be working with you a little bit. They don't have to accommodate you, but they can't just jump and terminate you the first time, you know, you're distracted at work because you're so upset about your association with a disabled person. So those are the three ways that an employee can argue the case. And in this case, there was no evidence of that. They truly had good documentation to show they terminated you because you didn't provide them any information that you were going to be able to return to work. And so what did they do well? Again, documentation. They had letters, they had phone calls, he didn't respond, and they could show they gave him every opportunity to do so. When are you coming back? This is a state law case regarding disability, Eisen versus Crandon School District. I was just at Crandon, not last summer, because no one went anywhere last summer, but I was at the races the year before. Pretty cool little community. So Sam was a janitor for the school, and he had back issues. No one disputed it. He went on FMLA. So the district uses, and a lot of school districts do this, a lot of large employers do this. They use the calendar year for federal, because under state, you use federal, or under state law, you use calendar years. So it's easier to have calendar year for federal. So he took, at the end of 2015, he took 6 weeks of FMLA. And right away, January 1, he became eligible again under federal. So we got another 12 weeks. So he's out almost 5 months. And the district on February 1st sent him a letter notifying him, which everyone should do, hey, FYI, your FMLA will be up on this date. We will need updated medical information from you at that point. Now they were a little strong and said, look, we could fire you if we don't get anything, which is kind of true, but I'm worried under ADA, you don't want to make that threat. You want to look like you're open to offering an accommodation post FMLA. So I think the letter is a little strong, but it is what it is. They sent a letter very clearly telling him they might be able to fire him if he doesn't communicate with them prior to the FMLA being up. So he does communicate. He drops off the letter on February 19th from his doctor that says Sam's going to be reevaluated in April. However, that's not what they asked for. They wanted a return to work date, not a reevaluation date. Those are different things. So they then have documentation to him saying, Sam, this is not enough. This doesn't tell us when you're coming back. We need something from your doctor letting us know when you're coming back. Just even if it's not 100% certain, but something. Nothing was given. So April 19th, they don't have anything. I think they even waited until his evaluation in April to see if he was going to be able to come back. He wasn't able to come back, and they terminated him. He brought a claim for failure to accommodate. And interestingly, he also said, and by the way, the district should have given me a year off because they have a policy in their handbook that says that they will give medical leaves for up to a year. So not only did they fail to accommodate me, they have a policy they didn't follow. And it went to the administrative law judge, as we talked about, then it went to Labor Industry Review Commission, and the Labor Commission said indefinite leave is never an accommodation, which is true. This is my mantra. If any of you ever worked with me on this issue, once we get to an indefinite situation, we feel comfortable we can cut the cord. That's under federal or state law. So reiterated here, there's no reason for the district to believe a several month more leave, another leave of several more months, to a year would have been a reasonable accommodation. There was no evidence. The doctor didn't say, give him 6 more months. He should be able to come back. There was nothing. So they don't have to offer, even though they have a policy, they don't have to offer this to him. So employer wins. He is now appealed to the Court of Appeals. So we'll see what happens with that. I don't know why the situation should be any different, but they have appealed. So I'll have an update on this next year. But keep in mind what we should also learn from this case. You should not have leave policies anywhere. I don't care if it's a year or 5 years, because the EEOC doesn't like leave policies. Leave policies mean you have something buried in a handbook that says, hey, we might give up to a year of leave, we might give up to 5 years of leave, what have you. There are 2 reasons why the EEOC doesn't like those. One is they think every situation should be tailored. So every accommodation should be tailored. So you don't want to have a policy where you're going to abide by the policy only and not offer an accommodation. And the other reason is they would argue even if a year goes by, you might have to give more. Now that's unlikely. A year is a long time, but it's possible. And I think you don't want to box yourself into a policy. You don't want to have that policy hanging out there. So you got to argue with employees every time about whether they get it or they don't get it. Why even have it? Just do a tailored analysis every time based on what you can do based on the undue hardship situation. One other thing just to point out is as you review your handbooks this year, if you do revisions, you want to make sure you're carving out those 3 separate accommodation policies. The EEOC is really focused on accommodation for pregnancy, disability, and religion. And as we're in COVID world with employees making claims they can't wear a mask because of religion or can't wear a mask because of disability, I'm seeing a lot more of those types of claims come up, and we want to make sure we have a policy where we did address accommodation. We went through the interactive process and we had a conclusion about whether we could accommodate or not. And I think that we're going to see that again with vaccines. We'll see it. We'll continue to see accommodation as being our world we live in. So break out those policies. Another disability case, I entitled it, "There's Nothing Else We Can Do Here." This is a very unfortunate but common scenario I see with clients regarding an employee who has a seizure. So in this case, Matt worked for Mercury Marine in the boat engine factory, and he was hired in 2011. And the case doesn't go into great detail. Well, he has epilepsy and he has seizures at work. And so we're not sure if how many seizures he had back then in 2011, but he did have seizures at work. And so Mercury Marine says, Brunswick Corporation says, look, you need a fitness for duty. You had a seizure at work. You're working in a boat factory. This is dangerous. We need to make sure you're safe. So he gets a fitness for duty. The doctor says he shouldn't be working in this job. And so they fired him and he sued. And there's litigation, and finally they end up settling, and they say, you can come back, but we're going to put you in a different job. So the case settles, and from 2012 through 2015, he has 15 seizures. Wow, this is a very tolerant company. They had actually put him in his workspace. They had padded it. They took him away from any machinery he could hurt himself on. He did have a real job there, but they really went above and beyond to accommodate this for him. So what the straw that broke the camel's back is in September on 2015, he's walking to get a drink of water. He's walking to the break room. He has a seizure. He falls into the path of an incoming forklift because he's on the plant floor. They don't have, they don't have a drone. They can, carry him into the break room. He's walking through the plant floor. Forklift is coming. Coworkers move him out of the way. He breaks his nose. It's just everyone's very concerned. So Mercury Marine says, we've done everything. You're not safe. We can't keep you safe. We're gonna let you go. There's nothing else we can do here. And he sues for failure to accommodate his disability. And I know the attorney that was representing him, and he's quite the bulldog. So the attorney argued, look, you didn't accommodate him. Despite the fact that they employed him for several years, let him have 15 seizures and padded his workplace, this attorney says, look, you could have restricted him walking around. Why were you letting him go to the break room and go to the restroom, which is ridiculous? And the attorney argued, well, why didn't you assign coworkers to walk with him anytime he had to go to the bathroom, or from his car into the workstation, or from the workstation back to his car at the end of the shift? That would have been an easy accommodation. And thankfully, Lurk said, no, that's ridiculous. We are not going to make this employer assign coworkers to walk with this man who could have a seizure at any time and cause them to be in an unsafe situation. The other thing the lawyer last minute argued is, well, you should have made him wear a helmet. First of all, this is not FMLA. This is ADA. This is Wisconsin law, disability law. Magic words are required. The employee has the responsibility to request the accommodation. Now, what I coach employers, and what you all probably do, is you do want to show in the interactive process you went through ideas, you maybe had some ideas of your own. The bottom line is, if the employee doesn't request it and we don't think of it, you can't litigate over it down the road and say, well, this might have worked. And so Lurk threw that out too. Look, there's no evidence he asked for any of these things. There is evidence they did a ton for him. He is clearly unsafe to work. Employer wins. So what we learned, look, they probably bent over, they took too long. They probably tolerated it too long, but they certainly did everything under the law to show that they were trying to accommodate him. So this is just a guideline. You guys all know this, interactive process. Make sure you engage in the interactive process. Never say never before you have fully gone through the interactive process. Sometimes it's better to try something just and hope it works and see if it works. And if it doesn't work, then you say you tried. Any questions about disability? Just a couple more FMLA things that we have an opinion letter now. The Department of Labor has said, if an employee has a disabled child and needs time off to attend meetings, doctor's appointments, school appointments, conferences regarding disabled child, and they cannot be scheduled outside work, that's FMLA. So I think we all know this, but it is a new opinion letter. We should all just remind ourselves, it doesn't have to be care for child. The child might not even be at the meeting, but it's care for a child because you're in the big picture caring for your disabled child by going to the meetings. This was from 2019, but I still have employers ask me about this. Employees don't get to choose to take FMLA or not take FMLA. If it's a serious health condition, it's FMLA. They don't get to save it. They don't get to say, I don't want FMLA. No, it's FMLA. That includes if it's work comp. If they have a serious health condition and it's also work comp, it's FMLA, run the FMLA. So I think you guys all know that, but just in case, I am still seeing some questions about it, so. All right, so on to race and sex. I have seen this issue has come up a couple times regarding posting a position. Wait, we have to post this position. Sam Alexander worked for the Milwaukee Housing Authority, and he worked there since 1988. So Sam was a long-term employee for MHA. And his supervisor, Dan, repeatedly told Sam, when I retire, you're gonna get my job. Sam, you're gonna be awesome at my job when I retire. Hey, you should do this. You should train in this area. Here, I'm gonna have you do this for the next few months so you know how to do it. Everything from Dan to Sam was, Dan is telling Sam he's gonna get his job, maintenance manager. So then as we get closer to Dan's retirement, Dan starts, oh, this James Wellman, we like him, he's white, Sam's black. No evidence really that Dan treated Sam any differently, but Dan started to befriend James. And in Sam's mind, he's still the heir apparent for this job, and nothing in his mind changes. There's no evidence there's any issue with Sam's performance, nothing changes with that. So in 2011, Dan says, hey, I'm gonna retire, yay, let's schedule the party. And Dan then recommends James for the job. So there's no rules at this organization for posting open position. They don't post the job. Based on Dan's recommendation, James just gets it. Sam has no idea. There's just an announcement, email send out, hey, James is now the maintenance manager. So what do you think? How do you think Sam felt? Super mad. So on paper, Sam is convinced he's more qualified than James on paper. So he can't believe he didn't even get to apply. He can't believe this position wasn't posted. So Sam files a claim with the Equal Rights Division. The investigator dismisses the case. I'm not sure that those aren't published. I don't know why. It seems like it's a pretty strong case, but Sam appealed, and the ALJ dismissed the case. Sam appealed, and Labor Industry Review Commission said, look, there's probable cause here that this organization could have decided on the basis of race whether or not Sam got the job or not. So there's enough here that Sam should at least get a hearing. So it's going to go back to get Sam a hearing. So what could they have done differently? Post the job. Post the job. Let everybody apply. Take good notes about who gets what and why. And I do see this occasionally where someone starts getting groomed for a promotion. Well, Sarah, do we have to post for a promotion? Well, why not? If yes, you think that John's going to get it. John's better on paper. John's been groomed. But why not just post it? Give everyone a fair opportunity to apply. So if you don't, this is what the risk you run. Now, this was a weird fact scenario because we have James telling Sam he's going to get it for several years. So Sam's really mad. But just a note about internal posting, external posting, what jobs you post, what jobs you don't, and why. That just creates hard feelings and creates litigation. This case, again, a hiring case, Joel versus Valparaiso Community Schools. Molly Joel coached cross country for the school district for 7 years, 2005 to 2012. And then she said, look, I need to resign. My kids are really busy. I just feel like I'm not being a good mom right now. I just need to resign. And they're like, fine, no problem. Well, a couple years later, she's like, okay, I'm good. I'm sick of my kids. I want to get back in the workplace. And so she applies for an assistant cross-country coach for the girls team. And a younger man was hired for that job. So she interviewed for the job. He interviewed for the job, and she didn't get it. And she's like, God, why wouldn't I get this job? This is so interesting. And she started to do her own little investigation. And she figured out, or she believed, this is because of sex. This is because I resigned first before because I wanted to be a mom. They held that against me, and I think I have a case for sex discrimination. So she sued. And the younger man testified in the lawsuit, yeah, I mean, nobody asked me about my family. I had resigned a previous job because I had some family issues and dad issues, or, wanted to spend more time with my kids. The whole interview, we just talked about coaching and cross country and all about the job. Whereas Molly testified, that's not how my interview went at all. It was all focused on, well, why did you resign again? Are you sure you were ready to come back into the workforce? How old are your kids? Like, how busy are they? It was all about her parenting issues. And so because that evidence came forward, that those two interviews were so different, the Seventh Circuit said, yes, there's enough here. Oh, she should get a jury trial on this. There is enough here that looks like they used a sexual stereotype in making their decision. So even though it wasn't because she was a woman necessarily, because she was a mother with children and needed, arguably they were using that, which is related to sex, sexual stereotype, actionable. So what could they have done differently? I mean, coach the people, no pun intended, who are doing these interviews so that they know they need, if they're not experiencing doing job interviews or interviewing applicants, give them lists, give them training, make sure they understand that they should be sticking to the agenda and the position and the discussion about whether the person can do the job. Another hiring case involving race, Barnes versus Illinois University. Greg Barnes worked as an engineer. He had worked there for many, many years as an engineer. He applies for the chief engineering job. Greg is African-American, so this is what the university posts it, which is great. Yay, A+, they post the job. And he applies. Greg is selected for an interview. And another engineer, Tony, who's white, he also applies to be interviewed, and he was selected to be interviewed. So we have Greg, who's African-American, Tony, who's white. Greg goes to the interview with nothing. He's an internal candidate. He thinks his experience speaks for itself. What he's done for the university thus far speaks for itself. He is a decent interview. He doesn't do anything wrong during the interview, but he doesn't really sell himself very well. Tony goes to the interview. He's got his resume. He's got a proposal on a certain project the university is planning to do and how he would have that run and how he would do RFPs for it. He has a narrative of his work history. He has lots of paperwork and he is ready to sell himself. And he does, and also does a great interview. And the supervisor is super impressed with Tony. So Tony gets the job. Now Greg says, wait, I've worked here longer. On paper, I have more experience. This has to be because of race. And Greg sues for race discrimination and loses because the interviewer had really good documentation and really could testify about exactly why he picked Tony over Greg. And he had very good notes he took during the interview, and he was very convincing in saying this has nothing to do with race. Here's how Tony wowed me during the interview. Yes, I realize Greg's worked here longer, maybe has a little more experience, but this is why I picked Tony. And so this case went the other way because management had a really, really good story to tell and they had evidence to back it up. This case is, this is an example of how an employer could just do things so poorly that that a jury isn't going to like you. And if you get in front of a jury and they don't like you, the law really doesn't matter. They have a lot of power. So in this case, Lydia started working for the Chicago Park District in 1987. So she's been there a long, long time. Somebody gets, I don't know if she has a disgruntled friend or boyfriend or girlfriend, but somebody called in 2011 and said, look, you got to watch Lydia. She is stealing time from you. She's writing down hours that she's not working. It's a big deal, obviously, for any employer. Take this allegation seriously, although it is anonymous. So how much weight do you give it? Got to balance that. But they gave it great weight and they started intense surveillance on her. And they could show that they surveyed her 252 times, which, okay, they want to find out if she's doing anything wrong. That's okay. That's not illegal. So months later, and there's a union involved, so some of this takes longer because she's going through the process with the union, but they did address with her 11 out of the 252 times they surveyed her, she had 11 timesheet where they called them falsifications, where she clearly wasn't in the building yet, or she was in the parking lot, or she wasn't there in their mind and she was writing down time. She said, wait, I can address all of these. Yes, one time I came in late because there was a dead body in the parking lot and I was helping somebody with it or in a park and I forgot to punch in and then I punched in later. I mean, she had an explanation for several of the issues. And HR just said, we're not going to talk to you. This is timesheet falsification. You are going to be disciplined. I don't care about your explanation. And several months passed again because they were going to fire her and she appealed through the union and that took a little while, but eventually she was fired. So she said, no, this is ridiculous. You guys scrutinized me because I'm Hispanic. Everyone does this. It was 11 mistakes. You scrutinized me for hours and hours and hours and hours. You found 11 tiny things wrong. This is race discrimination. I'm Hispanic. I'm suing. She gets all the way to a jury and the jury says, yes, we don't like that you were scrutinized. We think this was because of that you're Hispanic. She had some tiny evidence that there were white employees who weren't treated quite like this, but it wasn't that great. So really, I mean, she won because she had enough circumstantial evidence that she could get before the jury to convince them to not like her employer and think she was treated unfairly. So again, here, can they do intense surveillance? Yes. Did they ever do it for anyone else? No. So why were they doing it for her? And she's such a long-term employee. I think the lesson here is be very careful, especially when you have a long-term employee. Make sure you have justification for your actions. This is my favorite section every year. Although the most cases on my desk are disability discrimination, these are the most cases litigated every year under Wisconsin law. As far as arrest and conviction, if you go on the Labor Industry Review website, which is where the LIRC decisions are published, almost every year arrest and conviction cases are at the top of the list. Why? Individuals who have pending charges or are convicts, they know the law. They know exactly the law. Their criminal attorneys tell them very clearly the law. So if you fire them, they are going, and they think it's because of the conviction, they will bring a claim. This is one of those charges that can only be brought under state law, not with the EOC. So all these cases are under Equal Rights Division venue. Well, remember, all of you probably know this, if it's a conviction, you can only terminate someone if the conviction is substantially related to the job. If it's a pending charge, you can never terminate related to the pending charge, and you can suspend them only if it's substantially related to the job. And these cases, I think, are very interesting, and I think that's the best way to let you guys know how this actually works in the real world. Oops. Okay. So Boston versus Time Warner Cable. Britton Boston he applied for a CSR position. Lots of these jobs are applicants trying to get hired, right? He applies for a CSR position. He fills out an application that says, have you ever been convicted? No, we're not automatically going to exclude you from the job based on your convictions, but please list everything that you have been convicted of. And if you don't, and you're not complete, there's the thing on the application that says, if this is not complete, or we think you lied, you could be fired. So he does okay. He lists 3 of the 4, and he fails to disclose disorderly conduct. He lists 3 other ones. So they do a criminal background check, and it comes back with the DO conviction. They take the offer away. They say, you failed the background check. Oh, no, they don't even say that. They just say, we're withdrawing the offer. And I don't know verbally what was said to them. Nothing in writing was said, but something about we're taking the offer back based on the background check. So he's mad. He's like, wow, they can't rely on my disorderly conduct conviction. That has nothing to do with the job. So I'm going to sue. I know my rights. So he brought a claim, and he sues for arrest and conviction discrimination. And the Labor Industry Review Commission reviewed, he got to a hearing, and the Labor Industry Review Commission reviewed the judge's hearing and the testimony that was given at that hearing and said, look, the Time Warner Cable proved at the hearing that the reason that they did not offer him the job is he failed to disclose all 4 convictions. That is different than not giving him the job because of a conviction, right? Because he's supposed to fill out the form and he didn't. And it says on the bottom of the form, if you're too stupid to answer this correctly, we can fire you. We don't have to offer you the job. So it had nothing to do with the conviction itself. It's because he didn't fill out the form. And unfortunately, because what they could have done differently here is sent him a letter that said, Dear Britton, you screwed up. You didn't fill out the form. Here's what the form says. Here's what you should have put. You didn't put it, and we're not offering you the job. But because they didn't give him that clarity, he thought, well, I might as well try to sue for disorderly, for the conviction discrimination based on the disorderly conduct. So nowadays, remember this case was in, I guess I don't have the year. It was like 5 years ago when this started. You know, again, it takes 5 years for anything to get to LIRC, or 3 years ago, where we all were using applications that had this question on it. Now that is banned in so many states. I don't think anyone's even doing it anymore. Although you can still do that in Wisconsin, but if you're recruiting outside the state of Wisconsin, you probably don't even have that on your application. So not as big of an issue these days, but you can. If somebody lies or doesn't fill out something correctly, and that's why you didn't hire them, you should tell them that. That's the lesson of this case. 2012, Varga versus Preferred Sands. Again, this just shows these cases take years and years and years to get to the Labor Industry Review Commission. So this case is about deferred prosecution. Now, I've struggled with this myself because I didn't know what deferred prosecution was. And all of a sudden, I started have clients in the last couple of years calling and saying, well, we want to hire this person, but the background check comes back deferred prosecution. Is that a conviction? Is that a pending charge? What can we do with that? I didn't know. And since then, we've gotten some cases, including this one, that has provided some clarity on what deferred prosecution is under the arrest and conviction statute. So this is very important because we see prosecutors doing this all the time now. We used to never see it. So in 2012, David Varga was charged with multiple offenses of sexual assault of a child. He had 2 felonies and he had 2 misdemeanors. This is in 2012. For the felony charges, he pled guilty to the misdemeanors. And then for the felony charges, he entered into deferred prosecution. That is where the prosecutor says, look, we don't want you to go to prison for 20 years. We will defer your prosecution on the felony charge for 5 years. If you're a good boy for 5 years, it goes away. So you won't have it on your record. You don't have to go to prison. So and it could be 5 years, it could be 4 years, it could be 6 months. It just depends on the crime. So he's got a deferred prosecution agreement on the felony. He pleads guilty to the misdemeanor charges, which results in a registered sex offender status. He is a registered sex offender nationally. He's on the national register. Preferred Sands hires him in 2015. They don't do background checks. I don't know why. I mean, not everyone does. I do know why, because it's really hard to even, in some industries, it's hard to rule anybody out. But anyway, they don't do them. HR gets information from a coworker. This doesn't always happens. Hey, don't you know we just hired a sex offender? Like, doesn't anybody do background checks around here? So HR gets this information from a coworker that he's a sex offender. And the company then says, look, run a full background check on this guy. This is concerning. So they run a full background check, which reveals all of these charges and the deferred prosecution agreement. So HR interviews Varga regarding the felony charge only. These are the ones that are pending. These are pending charges, deferred prosecution charges. Based on the interview, they interviewed him. They said, we're not asking you about the convictions. We're not asking you about that at all. We just want to know about these pending charges. And he says, I did it. The detail's not there about why he did it, but he admits to HR, I did this chart. I'm trying to be a better person. I did this horrible thing, but I'm, trying to be better so it gets clean from my record. So they fire him and he sues for arrest and conviction discrimination. So this is a very critical piece of, I can get this to work. Why aren't you working? Hold on. So this is an exception when you have a pending charge, and everyone needs to know about this because Wisconsin, this is so frustrating that you can't do anything with this information normally. When you have a pending charge, you have the right to interview, do your own investigation into whether the employee or the applicant actually did the thing he's charged with. This is not a conviction yet. So you can call an employee and say, hey, employee, we see you have these pending charges. What's your story? Now, they don't have to, if they're smart, they probably wouldn't communicate with you at all. But if they're not smart and they admit doing it to you and you get that admission from them, it has nothing to do with what the cops are doing. Your whole decision is based on their admission to you that they did it. You can fire them. That is an exception to the pending charge rule because you're not relying on the pending charge. You're not relying on what they're charged with. You're firing them because they verbally admitted that they did it to you. And you did your own investigation and you concluded they did it. It's a very small exception. It only applies when there's a pending charge. So they used the Onalaska defense. They said, we met with him. He admitted these two pending charges, these felony deferred prosecution charges. He admitted he did it. And so we're firing this guy. And his lawyer said, no, a deferred prosecution is considered a conviction. And we didn't have solid ground on this issue before this case. And now the LERC said, no, deferred prosecution is not a conviction. It is a pending charge. So the Onalaska defense, which is what it's referred to, when you do your own investigation, conclude the employee did it, that applies. They did the right thing here. You can fire him. However, unfortunately, in the hearing, it was either the HR person or the in-house counsel testified. Well, part of the reason was because of his registered sex offender status. Like it was partly because he admitted that he did the felonies, but also can't deny the registered sex offender status made me a little queasy. So you can't rely on the conviction for the child sexual assault or the sexual sex offender status. That's not substantially related to the job, right? Sexual assault convictions are not related to the job unless the kids are around, which this is, there were no kids at this, it was a factory. So, okay, so you had a reason to fire him, but you screwed up by telling me that part of the reason in your brain was because of the sexual assault conviction, which you cannot use. So what did we do in this case? It's considered a mixed motive case. His limited remedy is attorney's fees. So he won $18,000. He has also appealed to the Wisconsin Court of Appeals. I don't know what they're going to decide differently. I think this was correctly decided, but he has appealed. He wants the full, benefit of, he wants a finding that they relied totally. I don't know what, or maybe they're going to try to argue deferred prosecution agreement should be a pending charge or should be a conviction. I don't know. But the lesson here, again, be very clear with people about why you're firing them. And this is in every case, but it's especially true in these arrest and conviction cases. So if you have the ability to do your own investigation and rely on that, make sure it is crystal clearly communicated that this is nothing to do with your previous record. This is based on our investigation. And you might want to put something in writing to the employee about that so that there's no argument down the road that you relied on something differently. Okay, no questions? You guys all know all of this stuff, not learning anything. Okay, this is my favorite case of the year. Palmer versus Cree Inc. So Derek Palmer applies for a lighting specialist position in 2017. And on his application, he checked, yes, I have a conviction, and he wrote down domestic related. Offer was made contingent on the background check, and the background check revealed 4 convictions. They didn't ask him to specify, by the way. So arguably he did fill out the application correctly. It was a very, there's no dispute that he filled it out. He wrote the domestic related. I think they asked him about it and he told them about all the things that they were going to find. So they make the offer, background check comes back. He has criminal damage to property, a misdemeanor, battery, a misdemeanor, strangulation and suffocation, a felony, 4th degree sexual assault, misdemeanor, all related to a domestic incident with ex-girlfriend or current girlfriend, whatever. It was all related to this one thing with his it was either ex-girlfriend or current girlfriend. So they said, this is yucky. We don't want this guy working for us. We're revoking the offer. And Derek sued the company for conviction discrimination. And the Equal Rights Division initially said, yeah, this sounds bad. This is a domestic conviction. This is not related to his job. So we think the employer did something wrong here. And there's a hearing. And the ALJ said, well, no, I think domestic assault is related to this job, because in the hearing, I was convinced by the employer saying there are lots of places this guy could be on site, not supervised, and women are all over the place. So I think it's likely he could reoffend with this record of domestic violence. And so the judge said, I think it's substantially related. Cree, you win, employer wins. Well, then Derek said, wait, that doesn't sound right. Let's appeal to the Labor Industry Review Commission. And the Labor Industry Review Commission said, look, the conviction has to be substantially related to the job. We have lots of case law that talks about battery, and a battery conviction is not substantially related to the job unless the employee is working with a vulnerable population, nursing homes, children, disabled people, healthcare. So that's clear. The battery cases, remember he had two batteries. He had one battery. He had battery, a misdemeanor. So the battery case, not related, clearly on the law. Regarding the sexual assault conviction, again, we have a lot of case law on this too, so I think the judge got it wrong. Lurk said, look, there is no substantial relationship because the assault convictions, the strangulation and the sexual assault were domestic. And here's what Lurk says, and this, no one's gonna like this, but this, I agree with this under the law. The fact that there are female employees in the plant with whom the complainant could possibly become involved in a personal relationship that might end badly is a scenario requiring a high degree of speculation and conjecture, and one that goes well beyond any reasonable concern about job-related conduct. So what they're saying is, look, he beat up his ex-wife and raped her, or ex-girlfriend. He doesn't work with his ex-wife. He doesn't work with his ex-girlfriend. And for you to say it's possible he might have a relationship with one of these women he works with, and it might go bad, and then he might beat her up, that's too much. That's too much of that's a long road. That's speculation. That does not make a domestic violence event substantially related to the job with regard to any possible woman he might work with. I don't like it, but I think that's the law. I agree with that decision. So we're not done. Labor Industry Review Commission says, Derek, you win. This was not related to the job, and that's in 2018. And they say, Derek, you win, you get full reinstatement, full vacation and benefits you would have received had you got the job in 2015, full back pay, and 12% interest and all your fees. Win, win, win for Derek. Big money. So Cree says, oh, not so fast. We still are going to appeal. They appeal to Racine County judge, which is the next step. Racine County judge says, I don't like the Lurk decision. I'm going to reverse it. That's in 2019. Derek says, wait, I'm going to appeal again. Derek appeals to the Wisconsin Court of Appeals. The Wisconsin Court of Appeals just decided this year. So we've been in litigation for 5 years now. Court of Appeals says, look, Racine judge, you don't know this. You're wrong. Lurk was right. And here's what the Court of Appeals says. And I think this is something that when you're talking to managers about how stupid this law is, that this is not our fault. This is what the law is, and this is how the law was drafted, and we just have to carry it out, and we don't have to like it. But I think this is really important. In enacting this law, protecting against conviction-based discrimination, our legislature chose not to exempt particularly disturbing offenses. The legislature could have had exceptions for first-degree intentional murder, first-degree sexual assault, strangulation, suffocation, fourth-degree sexual assault, all of these horrible things that Derek did. But there are no exceptions. The only exception is it substantially related to the job? And the Supreme Court, or the Wisconsin Court of Appeals said, we agree, this is not related. Cree still wins, or Derek wins, sorry, Derek wins. So the employer has now appealed to the Wisconsin Supreme Court. I can only imagine what the attorney's fees are for the employer for going from 2015, going through one hearing, Labor Industry Review Commission, Racine County Judge Review, Court of Appeals Review, and now Wisconsin Supreme Court. $250,000 at least. And so, I mean, I think it's more. I actually wanted to call the law firm to find out if they would tell me what the fees were, but for the law firm for the employee, because I'm sure he would tell me what they could have gotten. So anyway, bottom line is, I think the Wisconsin Supreme Court is going to follow the Court of Appeals. I don't know though. If they don't, we'll have a huge change in the law in the state on domestic violence. So stay tuned for that. I just have a couple more things. This is a new case under USERA, which is the Uniform Services Employment and Reemployment Rights Act, which protects military service members. So you're all probably aware of it. It's a federal law. And in this case, a bunch of pilots filed a class action against United. And their class action was, look, there is a policy, what happens to be a collective bargaining agreement, but that doesn't matter, it's a policy. They have a policy providing for jury duty pay and sick leave pay, but not military leave pay, which is very common. I see it in handbooks all the time. We will pay people to go to jury, we pay people for sick pay, military leave's unpaid. I mean, I see both, but it's not uncommon to see that military leave is not paid. District court said, well, that's okay. It doesn't have to be paid. The USERA is all about not discriminating against the military service member when they come back to work, so that they still get the same pay, right to reinstatement, same benefits. They don't have to get paid. That would be extra. And no court in the country has previously looked at this issue. This is brand new first impression. And the Seventh Circuit said, we don't know. They might be onto something. So we think there should be a jury trial on this. The district court ruled too soon. And at the very minimum, the district court needs to order some discovery, which is depositions, discovery documents exchanged. So basically, district court, not so fast. We think that there might be something here and you should have dismissed it. So you need to look at this again. So what does this mean? Well, right now it doesn't mean anything because it's still pending. So if you're like, oh my gosh, we don't pay anybody for military pay. We don't pay anybody for military leave. I wouldn't worry so much about that right now, but we were going to watch this case and see if the law comes out differently. So just a little FYI, you probably saw some SHRM announcements on this case.
Hey, Sarah, real quick question on this one.
Yeah.
So they're paid for their military leave. So say if I was in the military, I was going to whatever, I'm paid by the military for that time. Is this concentrating on the difference in what they would have been paid? Okay.
Yep. So
okay.
the jury duty argument is similar. So
yep.
It's like, what we would do, a lot of employers will pay you the difference. You get to keep the check or whatever.
Yep.
Yep.
Okay. Awesome. Thanks, Sarah.
Yeah. I just have a couple more. Okay. Just a word, I'm not going to go through them all, but every state, it is becoming increasingly difficult to keep up with all the state legislation. So when you have employees in another state, just before you pull the trigger on a positive drug test issue, before you ask somebody when you're interviewing them to give you the salary that they worked at their previous job, you want to make sure you look at state law because there have been salary bans passed all over. Legalization of drugs obviously changes every election. And then in several states, not Wisconsin, but several states have passed laws regarding different paid leave, sick pay, leave for other things, and COVID related leave. So whenever you're outside of Wisconsin, you have an employee asking about any of these issues, obviously minimum wage increases you're going to know about, but some of these things that we're not used to dealing with in Wisconsin, just always proceed with caution in those other states. Oh, this is just going slow. Just another FYI, I talked about this last year, but it keeps coming up. Remember that, if you just have paid leave for birth mothers under your STD policy, short-term disability, and no one else gets anything other than FMLA, that's okay. Might be okay. That's probably okay. But if you're giving maternity paid leave to women and not to men, or any other pay that is not the same for placement, adoption of a child, or you know, any sort of, if you have a parental leave policy that distinguishes against different types of employees, be very careful. Now, I still think you could have just a policy for the woman who has the baby, because they are technically disabled under your STD. They're eligible under STD. And if you don't have anything else for anyone else, that's fine. But make sure that if you do have paid leave for anyone else, that you are making it equal for women who can't give birth, women who adopt, women who have foster children placed, and men, all the same. So just, this was a focus before COVID. Obviously with COVID, a lot of agencies are looking at other things, but this, we have seen some cases come up in the press where men are not getting this equal leave as women, or there was one case where I read the employer said the primary provider gets the paid leave, the primary provider, and we assume that's the woman. We assume that's the woman unless you can prove to us it's going to be the man. Not a good idea. So they had to revise their policy. They got sued. Sexual harassment, again, I have a case that came in. I actually have been saying for months, and some of you probably have said it to you if you've called me for advice on other things. I've been saying for months, give me a sexual harassment case. I'm so sick of COVID stuff. I'm so sick of FFCRA. I finally got a doozy last week. And the whole point of this company that's getting sued is because of workplace romance. And a certain person in the company who's very high up, just thinks that the dating pool should start with the employees below him. And that is creating huge problems because, how do you argue that that's consensual? It's impossible. So that is a big, huge deal I'm dealing with right now. So just a little bit of guidance. Remember, with sexual harassment allegations, is it consensual? You'll never prove what's going on in anyone's head. So better to just keep an eye on it, better to not allow supervisor subordinate relationships unless you can move them so there's no conflict, and make sure everybody signs off that it's consensual. So sexual harassment investigation tips, again, the EOC has said, treat an active harasser like an active shooter, huge burden on the employer to end harassment as soon as possible. And we already talked about that a little earlier with disability harassment. Again, just some tips on sexual harassment investigation. There is no he said, she said. That is not a finding. If he said something and she says something and there's no other witnesses, you have to make a decision. Who do you believe? As the number one mistake I see in sexual harassment investigations is that there's no conclusion to the complaint. So the person complaining feels very like, no one listened to me. There's no conclusion. And the conclusion might be, we find him to be, we find you to be credible, we find him to be credible, we find no evidence, our conclusion is there's no evidence that a policy violation occurred. That's the conclusion. The conclusion can't be, well, we don't know who to believe. So those are that's a distinction that's very narrow, but you really want to make sure you're documenting to the person complaining that you did review the complaint and here is what you found. And it might be you cannot substantiate the allegations. That's okay. But you need to tell them that so that they are wondering what happened. So I know it's 12:30. I don't know how much time everyone devoted to this, but if there's any additional questions, you can ask them now. So, okay, well, everyone, I missed you. I missed being live in front of you. Hopefully next year I will be live. We'll be at one of your fabulous locations. And until then, you know how to find me. Bye. Thanks, Karen.
So thank you, Sarah. I appreciate you, Bob and Nicole sharing your talents today, your expertise and all of that. We do. After this meeting is concluded, I will be sure to share out your slides with everyone. I know that's usually a common question that gets
Yep.
Yeah, it takes place. I do want to open this up to those that are still on the line. Did you have, number one, questions for Sara or other things that you wanted to bring up while we have a brief audience yet? Feel free to unmute yourselves and
Yeah, just.
I don't have any questions, but I took a lot of good notes as usual.
Me too. Me too.
that's great. That's great. All right. Well, with that, our next meeting is March 17th. I'm actually working with a MAHRA member, Katie Zaleski, that is looking at, she's lining up a speaker for us that is going to discuss DEI, which you all probably know a lot about as well. But she's heard this speaker. She's actually, it's a good friend of hers. She was going to give you a highlight today, but unfortunately she had an employee issue today to take care of. With timing, you know, right? MAHRA and employees, right? I will get some information out to all of you soon. I'd like to, again, thank Sara and her team and Ware for being our speakers of today, and always insightful and appreciative of that. And then also Corey and her team for giving us that opportunity to have a discount on our lunch today. We at the Chamber did take advantage of it. I ran over there quick and got it. Jill had left this open until 2 o'clock today. So if you guys want to take advantage of the discount offer through Libby McNeil's, please do. They have some, we had the haddock sandwiches here, and I will tell you they are delicious. So I hope that you all enjoy that, and everybody have a wonderful rest of your day.
Thank you.
Thank you, Karen.